Thank you for joining our webinar on Justice Adapting the Saskatchewan Courts. Some housekeeping notes. If you experience technical difficulty at any point, please exit the meeting and re-enter using the link provided. Note that this session is being recorded and LexisNexis will distribute the link in a timely manner. On behalf of the judges and LexisNexis, we hope you are staying safe during these unsettling times, and thank you for doing your part to flatten the curve. As COVID-19 events continue to unfold, LexisNexis Canada is supporting the legal community. The Practice Advisor Coronavirus Resource page provides a document kit that can be downloaded for free. Please visit lexisnexis.ca/COVID-19 for more information. Today's webinar will now begin. I would like to introduce the moderator, Timon Sisik from LexisNexis Canada. Timon, over to you.
Hello and welcome everyone to LexisNexis's COVID-19 Justice Adapting webinar series. I'm Timon Sisik and I will be the moderator for today's panel discussion. This webinar is part of a series of discussions LexisNexis is presenting across Canada to bring the legal community together in sharing updates and information about how lawyers, the law societies, and the courts are adapting to the pandemic. Today, we are fortunate enough to have with us on our panel the Chief Judges and Justices from 3 different Saskatchewan courts to share their experiences and insights. Joining us today are the Honorable Chief Justice Robert Richards of the Saskatchewan Court of Appeal, the Honorable Chief Justice Martel Popescu of the Court of the Queen's Bench, the Honorable Judge Earl Callanith of the Provincial Court, and the Honorable Judge Bruce Bauer of the Provincial Court. I believe everyone listening already recognizes generally the unprecedented impact this pandemic has had on our justice system, so I won't dwell on that. We also recognize that the situation is rapidly changing daily and that the information we have is in flux. However, we believe that open lines of communication within our community are key to ensuring the justice system and its participants remain resilient and adaptive to the challenges ahead. As such, we greatly appreciate the panelists for taking the time to join us today. The format of our panel discussion will take the form of a question that I will ask to the panel and then invite each panelist to weigh in on that issue. Some of the questions will be generally applicable across the courts, whereas others will be related to only one court. This webinar is accredited for 1 hour of substantive CPD credit, and because we only do have 1 hour, I would like to take advantage of the time and keep this introduction brief. So with that, I will start with our first question. As a matter of introduction, I'd ask each of our panelist judges to please provide a brief overview of the major changes each of your courts have implemented. I understand that there are rather lengthy notices to the profession that most of our viewers are familiar with, so I won't ask you to repeat those. But could you simply give a summary each from your courts as to what some important news should be highlighted before we explore the more specific questions? I'll start with the Honorable Chief Justice Richards from the Court of Appeal. Chief Justice Richards.
For the Court of Appeal, the 2 notices to the profession that are posted on the court's website say it all. I think when we saw the COVID situation on the horizon, we moved pretty aggressively to try to get a video system in place that would allow us to hear appeals and applications by way of a video link. We were able to do that and to move happily, pretty seamlessly into an environment where we were hearing all of our matters both by way of teleconference and video conference. Effective March 23rd, we moved to a situation where all of our hearings were done electronically. And since that time, both for chambers matters and for regular appeals, that's how we've been operating, either by way of conference call or WebEx, which is the video link system that we elected. We've maintained our, we've maintained our regular sitting schedule, and we've been able to process and hear appeals happily enough at the standard or normal rate. So we're in a much easier to manage situation than the trial courts. But to be blunt, we really haven't missed a beat, except for the fact we've transitioned to electronic type formats for hearing matters.
Thank you. Chief Justice Papascu.
Well, thank you very much. We have three directives that have been issued by the courts. One on March 15th, one on March 19th, the other one on April 23rd, and we have another one that will be coming out shortly. And essentially what occurred is initially we had to turn down the tap with respect to what we were hearing and what we were doing. And that was done somewhat gradually on March 15th, where we restricted the hearings to video only and encouraged parties to adjourn their trials. By March 19th, the landscape had shifted significantly such that the March 15th directive became unnecessary, and we had to move more aggressively to shut things down more substantially. For the most part, trials have been adjourned into June or the fall, and but a number of matters still continue to proceed, in particular urgent matters. By way of April 23rd, we are starting a reopening phase, and as of May 1st, we started to hear case conferences and appearance day notices, and come June 1st, we are going to be aggressively attacking our chambers list and having pretrial conferences resumed as of June 1st, and adding quite a few more pretrial conferences in July and August to ensure that we're in relatively good shape come September 1st.
Okay, thank you, Chief Justice Papascu. And from Judge Kalaniff, please.
Sure. In relation to the provincial court, our doors have been closed on our rural circuit points with notices on our website and the exterior of the building and the RCMP detachments. Those notices set out the dates of the future court dates and how to get a hold of the court and prosecutor. The courts we are conducting have been done by phone and video. We're still doing bail hearings and pleas and sentencings of custody and non-custody matters. In certain cases, in-custody trials have been conducted, ensuring that the requirements that parties are asymptomatic, willing to attend court, and we can be assured that we can maintain social distancing. Our civil matters through small claims court have all been postponed with protecting claimants' limitation rights. We're contributing to maintaining our usual processes for child protection by phone appearances that have not had to deal with any hearings with witnesses. Those are the main changes and limitations for our court.
Okay, thank you. And Judge Bauer, Judge Kalaniff, I'll go back and forth with you with respect to the provincial courts, but Judge Bauer, if there's anything you'd like to add on this point, feel free.
The main issue that we've had to come up against is that we are mainly a rural court system. We have 13 permanent courthouses in the cities, but we have approximately 70 circuit points, and we've had to close them all. So what we've done for there is to do those points by telephone and video, and by having signs on the doors just saying your court today is adjourned to a specific date in the future, and hopefully we'll get back up and running by that date.
Okay, thank you. So my next question is, it's interesting to see the different responses across the provinces. In Ontario, courts have completely closed for in-person hearings and are hearing matters only virtually. Even those are restricted to urgent matters only. As mentioned, Saskatchewan has taken a slightly less aggressive approach. Saskatchewan courts remain open for some urgent and emergency in-person hearings. Do you foresee Saskatchewan going down a similar route with further court closures? And can you speak to why you believe this difference exists between the courts? And this is an open question for all of the justices and judges.
Well, I'll just say a quick word on behalf of the Court of Appeal. I don't see anything changing for us, regardless of which way the pandemic moves. We're pretty much insulated from circumstances that are attached to the intensity of the pandemic, as I explained earlier. So your question is one that would have some impact on the trial courts, but as far as the Court of Appeal goes, we're hunkered down in a situation where we're hearing appeals where we have judges at home, court clerk at home, and lawyers at home or in their offices if they so choose. So we're pretty much insulated, at least for the time being, from the waves that are caused by the intensity of the pandemic moving up and down.
Yes.
On behalf of the Court of Queen's Bench, I can say this, is that we have remained open for business in the sense that Chambers has continued on, and Chambers is for urgent and emergency matters, and we're doing that by telephone. However, there have been some matters, not a lot, but some where the judge has determined that an in-custody trial ought to take place. And provided that the judge is of the view that the trial can be accommodated, we are proceeding with in-person trials in Saskatchewan. So what that would mean is that people would still come to court. There would be the appropriate social distancing that is occurring. Members of the public are not encouraged to come, but they can attend if they wish, as can media as well. Currently, we have a process whereby only a certain number of people are allowed to be in a courtroom. And on one occasion, it appeared that we might exceed that number. And so I directed that a second courtroom be opened so that the overflow of 5 or so people could be there and watch it by video link. Come June, there's going to be a number of trials that are going to be proceeding. And some are going to be perhaps in person, some will be video link, and some might be a combination of the two. So we're trying to find ways to make things happen and not find ways to ensure that they don't happen.
Thank you. And Judge Bauer, do you have anything to add on what the difference between the provinces?
But for the most part, we have not restricted ourselves to urgent matters. We have stopped our non-custody trials, but we have been doing in-custody trials where we feel that it's safe to do so. We've also are using technology to continue to conduct bail hearings, dockets where pleas are entered. We've been doing sentencings by phone and by video. And so it's not just emergency matters. I think part of the reason might be the difference between us and some of the other provinces is that we've used video to cover a lot of the North on an ongoing basis. It's expensive to fly into a community, and it's a lot easier if we can conduct our day-to-day docket matters by video. And so we've done that in the North and continue to do that while the COVID crisis has been going on.
Okay, so it's a matter of being prepared beforehand as a result of circumstance. Yes.
Right. Yeah. Exactly.
Thank you. So going back to the notices to the profession, I understand from the notices to the profession that some hearings are being heard by phone and some by video. I understand that from previous comments that WebEx is the video conferencing program of choice. Which matters are being heard by video conference as opposed to by phone, and how is that decision being made? Is that an important or substantial decision at all, or is it how are those made? And this one would go to Chief Justice Papaschool.
Okay, well, thank you. For Chambers, and in Saskatchewan, Chambers is a major part. All our chambers are being done by telephone and not by WebEx. So when somebody's going to be appearing by telephone in Chambers, that's the way it's been happening. We are looking at introducing or reintroducing our pretrial conference system. And that's where we may be using WebEx, or we may be using Zoom, or we may be using whatever technology is available to us come June 1st when we recommence that process. And I think part of your question is when would we decide if something's going to be in person as opposed by WebEx? And what I've attempted to do is leave those decisions up to the individual judge. So I will assign the judge the pretrials, and the judge will determine how that pretrial conference will occur. So for example, if it's in Regina or Saskatoon, and we do have, especially in Saskatoon, some bigger pretrial rooms, I don't see it as problematic for a judge to enter the pretrial room and maintain social distancing from the two parties and the two lawyers who can maintain social distancing amongst themselves. So if you think about it, 5 people in a great big room we should be able to accommodate that. Apparently people are going to liquor stores and grocery stores. So if they can go to a liquor store or grocery store, certainly we can find a way to have those 5 people in that room at that time. On the other hand, if people need to travel from out of town, they're in a smaller center, let's say, and they want to do it by WebEx and the judge agrees that's appropriate, then we'll do that. We in Saskatchewan and in our court, and I think the other courts as well, have always prided ourselves as being one that embraces innovation. And again, as I've said before, we're trying to find ways to make things happen as opposed to reasons why they cannot.
Okay, thank you very much.
As for provincial court, I can add that WebEx is just being tested at this time for use in civil case management conferences. For our in-custody matters, we've been using closed circuit TV, as Judge Bauer has mentioned, for an extended period of time. And so there are in-custody connection, or there are closed circuit connections to the correctional centers for substantive matters such as show cause hearings and sentencings. And there are connections to various police stations. And there are connections to some of the northern communities as well. In large part, it's been phone for many places to continue first appearances for arrests from police stations, from correctional centers where video can't happen. That's been the main use of the connections.
Thank you very much. This question is for all the judges that are dealing with limitation periods to any extent. Ontario, Alberta, British Columbia, and Quebec have suspended their limitations periods. Would you be happy to see some suspension or relaxation of limitation periods at this time, or do you not think it would be a wise idea? Why or why not? And I do take note that Judge Callanath, you had mentioned something with respect to limitations periods in small claims court, so I acknowledge that as well. And I guess I'll start with you with that question. Would you like to see a further relaxation of limitation periods in any respect, or do you not think it would be a wise idea?
Well, in respect of our court limitation, we recognize the protection of the parties that limitation periods provide. We're open to filing to allow parties to meet the limitation periods and have continued to allow filings to occur. We think that extending them is really a policy decision of government. Regarding filing deadlines, we've certainly required continued compliance with orders that were made before. We do now and have always continued to exercise flexibility so long as it doesn't affect fair hearing for parties.
And Chief Justice Richards, has there been any consideration of relaxation of any types of filing deadlines with the Court of Appeal, or is it, as you said earlier, business as usual, even with respect to those deadlines?
Our notice to the profession of March 20 says that, of course, the Court of Appeal on its own initiative can't change limitation periods. That's a function of statute that has to be addressed by the government and the legislature if necessary. But with respect to filing deadlines, we've indicated in the notice I just referenced that if any lawyer is encountering difficulties meeting a filing deadline because of circumstances related to COVID-19, that they're free to contact the registry office. And I think it goes without saying that we'd be pretty accommodating on that front.
Okay. And Chief Justice Papascool, is that the equivalent in your court?
Right. I agree with the comments of Judge Calumet and Chief Justice Richards in that as far as the limitation periods themselves, that's for government to decide. As far as the filing deadlines, because we continue to have business as usual as best we can, the filing deadlines need to remain and be in existence and be adhered to. However, if there's special circumstances as to why that can't happen, especially due to COVID-19, we're open to looking at relaxing those where necessary, as we do in most situations.
Okay, thank you. I'll direct this question first to the provincial judges here, but of the changes that were implemented in your daily procedures and in your decisions, how much of it was an exercise of your discretion as opposed to those changes put in writing to the notices to the profession or regulations? Just a little bit of elaboration on this. What I mean by that is I recognize that only so much can be written out and anticipated in notices to the profession. Have you had to exercise your discretion in an unusual manner with respect to granting orders at this time, or has it been just run of the mill, no particular change? And I guess I'll start with Judge Bauer on this one.
Well, one of the main areas where we've instituted changes is with respect to orders that have been made by the court. Previously, the person would then have to remain in the courthouse until the order was prepared and then signed, and he would sign it and acknowledge that he's received it and received all the instructions. And now what we're doing is making sure that we go through all of the aspects of the order in the courtroom, in addition to the aspects required in the criminal code, which say that we have to notify them of all the possibilities of changes to it or problems if they don't comply with it. And now we end up mailing those out after we followed all the steps that were previously done outside the courtroom. And so, that's one adaptation we've done in order to do our sentencings by telephone or by video that we didn't have in place before. So that's one of our adaptations at this point.
Okay, thank you. And Judge Calumet, have you had any experience with using your discretion to make sort of unusual orders, or has it mostly been in the course of things?
I don't think during this time I've made many more unusual orders than I usually make, but I would have to say that there have been some local differences that different court-based circuits have adopted some slightly different procedures to make it work best for them, because there are some differences between the locations, but otherwise I don't have anything to add to what Judge Bauer said.
Okay, thank you. And speaking of unusual orders, this question is for Justice Richards. Justice Richards, I recognize that you can't look into the future, but do you predict or expect that there might be an influx of appeals on procedural issues coming from the orders granted at this time as a result of the types of alterations that may be made by trial judges to conventional procedure?
I suppose anytime a judge or a lawyer is put in a circumstance that's new or put into waters that are uncharted or asked to solve a problem where there's no playbook, it gives rise, gives rise to situations where there might be disagreements as to whether the right call was ultimately made, and disagreements as to right calls are what leads to appeal. So there's, I suppose, some prospect for that. But at the same time, I recognize that the bar and the trial courts are working pretty hard to get things right. So if you have to ask me to predict at this point whether there be some kind of rash of appeals related to procedural matters flowing out of the COVID situation, I'm not really expecting that. But as you started out at the beginning by noting, I don't have a crystal ball.
Okay, thank you. So this one, I'll start this one with Chief Justice Papascool. Many motions have been adjourned because they don't reach a threshold level of urgency, although I imagine the case law is still fresh on this. Can you briefly describe what constitutes urgent in a civil family any criminal case. As the time goes on and parties' incomes are impacted by COVID-19, do you think that a motion that was not urgent to a party may suddenly become very urgent?
Okay, first of all, with respect to the question of what is urgent and what is not, there have been a number of decisions written by judges of our court and judges throughout the country about what urgent and not urgent would be.
Mm-hmm.
So I think that it's very fact specific and depends on the circumstances and the jurisprudences there. I must say that anecdotally, I have been somewhat surprised that the lawyers have not been pushing the envelope, so to speak. Most of the matters that have come before the court have been labeled as urgent, have been determined to be urgent. And oftentimes, even matters that are not all that important, but say an order needs to be extended because if it doesn't extend, somebody's going to lose a right, that would be urgent, even though it may not in the total scheme of things be that important. As far as where things go from here, we are scheduled as of June 1st to remove the urgent requirement. So come June 1st of this year, we will not be seeing cases because all chambers matters will be heard in the usual and ordinary course. Now, if there's a second wave and if things change, that could reset the boundaries and we might have to go back to that. But I think for the most part, people have been quite reluctant to proceed and label something as urgent. But the matters that have been coming forward are for the most part clearly within the urgent category.
Okay, thank you. And Judge Callanath, I know you mentioned that your courts weren't restricted to urgent matters, but if the provincial judges wanted to take the opportunity to speak about the difference between urgency and not, the opportunity is there.
As I mentioned before, we certainly have ranked matters. Our greatest volume of work is in criminal law. We've continued with the in-custody trials. Priority in scheduling is going to be to those detained awaiting trial and various other priorities as we then deal with the issue of non-custody trials that can proceed and backlogs that result. So violent and vulnerable witness cases are going to be also a high priority. Judge Bauer, I think, has mentioned that in relation to the issue of matters where people are on restricted release conditions, where they have other administrative detriments by reason of, say, driving prohibitions, those two are matters that we're going to seek to proceed on as soon as they can be.
Okay, thank you. Judge Bauer, you touched on something earlier about the circuit courts being impacted and the remote communities essentially being closed. You mentioned a few measures that are being taken to ensure that these communities are serviced, many of them being First Nations communities. This one question was specifically targeted at that, but is there any, are there any plans with respect to how these communities are going to be serviced? Because it is, as you mentioned, an important aspect of Saskatchewan.
I think our communities will depend a bit on the north-south shift, whether you're in the north or in the south. I know that in the northern areas, we are having further outbreaks of COVID. And so it's likely that those places are going to be closed longer. A lot of the places we go are, we can only access by plane. And so that makes it more difficult to have even a court party travel up there in a small plane and try and maintain social distancing. So given all the difficulties of getting into the north, we're going to likely have to have trials done in the courthouses that the northern circuits come from, which would be mainly Meadow Lake, Prince Albert, and Larange circuits. And so as a result of the problems there, trials may have to be moved. we're still servicing those communities via telephone and video where we can. And hopefully we'll be able to get more video into the communities where we don't need to go into the community because the video is already there and set up. And so it won't be introducing new people into the community, and we can get the buildings open where the videos are, and we can provide timely access for them to the courts as well.
Okay, thank you. This question is for all of the justices and judges, but I'll start with Chief Justice Richards. Which of the changes the court has experienced do you think will and should remain after the pandemic is over? Now, Chief Justice Richards, I know that you've repeated that that everything has gone fairly smoothly, relatively smoothly, but if there are any changes that the Court of Appeal has taken, which would you like to see going forward after the pandemic is over, if any?
The effectiveness of video appeals has been a bit of a surprise, I think, to me and my colleagues on the court, a surprise in the sense that we've been struck at how effective they are actually. And anecdotally, I hear that members of the bar who've participated in those appeals have come away with the same impression. In fact, one of my colleagues was telling me last week that he bumped into a lawyer who had argued a video appeal and had concluded that he thought it was better than arguing in person. So I expect that when the dust settles here, we're going to have to take a hard look at the availability of a video option for counsel. If you're a lawyer in Estevan and you're looking at having to drive up to Regina to argue an appeal, or if you're a lawyer in Meadow Lake and you're looking at having to drive to Saskatoon or Regina to argue an appeal, and you were presented with the option of being able to do it by way of WebEx, you might well go with that option to save you and your client many, many hours of travel time. So that's the feature, I think, that from the Court of Appeals perspective is an interesting one that the COVID experiment has brought to pretty clear light. So we're going to have a serious discussion about maybe extending the availability of video appeals into the post-COVID world, just because I think there are some efficiencies there that we may want to give the bar and the bar's clients an option of capturing.
Chief Justice Papaschool, do you have the same sentiment with respect to video about, and in your context, examinations being conducted by video, or even exhibits being entered by video?
Well, there again, it's always been, excuse me for a moment. It's always been a fact that we have had video conferencing. We have had chambers by telephone, and I think what we're finding is that more of that is a better thing than we thought before. So I think that doing more applications by telephone and more by video link is going to be something that I think that we're going to embrace. There were some judges and lawyers who were a little reluctant to head in a certain direction. In other words, they want to be there. They want to see the judge and how he or she reacts. And they're finding out that by doing it by telephone is just as good, as Chief Justice Richards had indicated. So I think that all in all, it would be embracing technology, which is something that we have always wanted to do, but the court itself doesn't have the money to do that. But I think that what will happen is that the governments will realize that it's a more efficient way of doing things.
Okay, just hoping. Judge Kalanath and Judge Bauer, do you have anything to add from the provincial courts?
Well, just that I think we too have found that the use of phone has been quite effective regarding much of, in particular, the docket courts that we do. It's anticipated there's going to be an increased use of that given the length with which the issues relating to the pandemic are going to still impact on our work and the benefits that come from access to justice. It's not just lawyers who have been appearing by phone on matters, but so have self-represented accused, and it's something that we'll continue to use as it will assist us in working going forward.
Okay, thank you. And Judge Bauer, has everything been covered, or do you have anything you'd like to see going forward?
I think it's all been covered. We have been using video and audio for a long time, and more so as the further north you go. And I think now everyone's finding out the advantages of it, and hopefully we'll be using more and more of it.
Okay, thank you. This is another question that goes to all of the judges. Has your experience changed working with your own administrative staff, whether remotely or in the court, as well as your internal research services? How can you give us a little bit of explanation on anything that's changed with your own administrative staff? And I'll start with Chief Justice Richards.
Well, we're operating behind the curtain, so to speak, very differently than we were pre-COVID. Virtually all of my colleagues, all of the judges on the court are working remotely from home. The large part of our support staff are working remotely from home as well. We're able to do that because for about 8 years, we've had this a system in place that we call the ECourt system. It's an electronic filing and file management system. So we've been able to disperse, but keep our hands on all of the raw materials that we use to do our work. And again, this has come as a bit of a surprise. I think it's been extraordinarily successful. We've got a very professional, committed staff. And when they say they're at home working, they're at home working. And all of my colleagues are reporting that things are going really pretty swimmingly, even though the large majority of folks in this building, or on this floor of this building, are working remotely. The corridors here at the Court of Appeal are usually relatively quiet, but they're extraordinarily quiet these days. Nonetheless, we're carrying on with business as usual because we've got this ECourt system in place that allows us to work pretty effectively at a distance. So that's come as a surprise to me, a pleasant surprise, but it's working pretty well.
Chief Justice Papascool, have you had similar experience with your administrative staff, your support staff?
Yes, I think it's safe to say that just about all the judges, if not all the judges of our court, have home offices and have from time to time worked from their home office. Our administrative staff, we've split them up so that some are working from home and some are working here, and they alternate, because there is some requirements that people do in fact need to sign documents and do a few things that need to be done in the courthouse per se. But I think, again, it's a realization about how effective you can be. And I know that I worked remotely from home for several weeks and found, quite frankly, that I could be more efficient because I didn't have to utilize all this time putting on a suit and driving to work, where I could be at my desk at 7:30 in the morning and work for, actually, as it turns out, longer hours more efficiently. And I think we're all finding that to be the case.
Okay, thank you. And Judge Bauer, would you agree with respect to that on the administrative side of things? And the
From the administrative side of things, yes, we don't have video access at our home offices. We have closed circuit TV for our correctional center and police station connections, and so there are some judges who are required to be in the courthouse and do the court in the courthouse. But when we are out of the courts and doing our court from home, the administrative staff has been outstanding in getting us all the material that we need. We weren't set up for it like the Court of Appeal. The administrative staff has to do some extra work in order for us to be able to work from home. But they've just been excellent at that, and it goes quite smoothly doing the courts from your home.
All right, thank you very much. To our next question here, what I find interesting is the issue of interpreters. Now, oftentimes it's difficult to run court proceedings with interpreters in the first place because there's a little bit of overlap there. Have any of the judges experienced any type of difficulty with interpreter participation for remote hearings and video conferencing or telephone conferencing, or has it been running smoothly? And I'll start with Judge Calanith on this one.
Well, we haven't used and had trials where interpreters have been needed during this time, but historically, sometimes it's been necessary that interpreters are used by phone. As long as the sound quality is good, then it's functioned just fine. It depends on, obviously, the skill of the interpreter and the sound quality for them to hear. So while it hasn't been a new or different issue now, it's something that historically we've dealt with. It's a much bigger challenge if the issue is hearing and speech impaired because it can be slower so as to involve translation, questions and answers in writing or by sign language.
That's actually an interesting point I hadn't really thought about, which is the hearing and speech impaired. If anybody else would like to comment on that or their experience with that during this time, I'll open that up. But as well with respect to the translators or the interpreters, Chief Justice Papaschool, have you had any experience with that?
As far as I'm aware, we haven't as yet had a situation where we have required or needed an interpreter during this pandemic period. So I can anticipate that it would be a challenge because sometimes cross-examining witness through an interpreter is difficult at the best of times, let alone virtually. But I really don't have any experience and nobody has indicated anything to me. And so I don't think that we've had that situation arise during this COVID period.
Okay. If there are no further comments on that, I'll move to the next question here. This is a question for Chief Justice Richards. The Court of Appeal updates say that if, quote, if a party believes an in-person oral hearing is necessary, he or she shall explain the reasons for so believing in a letter or email to the registrar. The Chief Justice or his designate will then make a ruling on how and when the matter will proceed. What factors will Your Honor take into account in determining whether to approve an in-person hearing?
Fairness and justice are the bottom lines there, and those would play out in different ways in different factual circumstances. We really haven't had much traffic on this particular issue. There's only been one occasion where a lawyer made a pitch for an in-person hearing. The rationale for that request was that she was appearing as co-counsel with another lawyer who was in another city. Her concern was that she wouldn't be able to whisper and pass notes during the course of argument the way lawyers sometimes do when they're tag teaming on a case. I rejected that application for an in-person hearing because it came with a request that the matter just be moved down the road until we were back fully in business with in-person hearings. My rationale for rejecting it was that I thought the matter could go ahead in a way that was fully fair and allowed for effective representation from that side of the courtroom, because there are many ways to communicate, even electronically during the course of submissions. You can send text messages to co-counsel, you can send emails to co-counsel, you can Skype to co-counsel, you can use the sidebar conversation feature of WebEx to co-counsel. So I decided that that wasn't a compelling enough reason to delay the court's calendar and to kick that particular appeal down the road. But as I say, we haven't had much traffic in this area. The bottom line would always be, can we ensure fairness and ensure a just and effective appeal process?
All right. In any case, any example is really helpful. So thank you for that. I know the bar appreciates any example or experience that comes out so that we can look at that and say, okay, well, I shouldn't ask for that type of relief, or it would be a waste of time to do so. So we have another one added there. That actually brings me to my next question here. Costs are regularly used to deter counsel from unprofessional practice, sharp practice, or from causing delays. In assessing scales of cost to award for various proceedings, have you adjusted the severity of costs awarded in order to further dissuade counsel from taking any advantage of the current situation? During this time, is there any type of conduct that you have encountered by lawyers in your courts that you would like to discourage, or any type of conduct you'd like to discourage in advance that you would anticipate? I will bring this question first to Chief Justice Papascu, because it's potentially most relevant with respect to the cost portion, but I'll open it up to everyone else in a moment.
Okay. As far as costs are concerned, we haven't done anything specific with respect to COVID-19 related situations. And I can say that costs is a very, again, peculiar matter where each situation depends upon its facts. And thus far, I don't think we've seen anything that has justified any sort of excessive costs order that would be what I'll call out of the ordinary. There certainly are cases that are being generated as a result of COVID-19. For example, parents who are saying that the other parent isn't respecting the COVID-19 social distancing and those types of things, and they may or may not attract costs depending upon the circumstances. So I think what we're dealing with is business as usual as far as costs are concerned. And I think the lawyers have been most responsible, and we haven't seen any real problems, and I don't anticipate any problems in the future in this province.
Okay, thank you. And do the other judges share the same sentiment? Have there been any type of conduct that you'd like to dissuade, or has it been rather smooth across your courts? And I'll put that to Judge Bauer first.
No, we've had counsel conducting themselves with integrity, and so we really haven't had a problem. In provincial court, we have limited ability to assess costs, and I haven't come upon a case yet, even during the time that we've had COVID, where costs could be an issue. So it's I don't think that we don't have the ability, and I don't think we need it.
Okay, that's excellent. Something I'd like to share, because we've done this webinar in Ontario, Manitoba, and BC so far. We've asked a similar question, and so far the responses have been very similar. So it's great to see that across Canada there's been a general respect for the court system and respect from one another coming from the bar. So I'm glad that the answer to that question wasn't more dramatic. My next question is general here. It's, what do we think the impacts of the situation will be for the future of the court system in Saskatchewan? I know I asked a few more specific questions on this earlier, but if you have anything general to add, if you feel like the court system will change outside of the comments that you mentioned earlier about greater video conferencing, I'd open up the panel to share those now. I'll start with Judge Caleneth, if you have any thoughts on that. If not, we'll move up the panel list.
Well, the only thing I would add is that, as Judge Bauer has mentioned, Northern Circuit points are a big issue for our court. There's a significant volume there of matters that have not been able to be dealt with. There's going to be a need to look at ways of conducting trials, especially for those who are bail denied and remanded, waiting trials, which, if they're held in their home committee, are going to be some extended period of time from now, and coming up with ways to ensure that the accused is before the court as the trial can be heard, but looking at other ways to facilitate and hear those trials so that they're not waiting for, inappropriately lengthy times to have those trials heard.
Okay. Thank you. Chief Justice Papaschool, is there anything else you'd like to see?
Well, if your question is what impact is this going to have,
Yes.
there's no question that even with the efforts that we're making to expedite chambers in June and having lots of additional pretrial conferences in July and August, come September, we are going to have a backlog of cases that are going to need to be heard. And it's going to be a challenge to figure out how we're going to manage that as best we can. I realize that criminal matters are important, as are family matters, as are civil matters, and how we do that and how we triage it and how we act efficiently is going to be a real challenge for the court. And even how we do jury trials is going to be something that we're going to have to consider. We're not sure if we will be able to conduct what I'll call a regular jury trial, where we summon 100 or so people into a room and pick 12 people out of that pool in September or October. And it's one thing to kick a trial from March until September, but I don't know that it's appropriate to kick a trial from September into the unforeseeable future. Mm-hmm. So it may be that we're going to have to devise some innovative methods by which we can continue to have jury trials to which certain accused people are entitled. And that will be an impact and a challenge all wrapped up into one.
Thank you. I actually had, we were taking pre-submitted questions here, but I had a question that came in that was related to this for Chief Justice Papaschool. So if you'd like to answer this, please, if you're able. The question is, how will dates be assigned for the Chamber's Blitz dates coming up in June? I'm not sure if that's relevant, but...
I think it's relevant and
okay.
Probably on the minds of many lawyers out there. And I can tell you that we're working on the next practice directive, which will be issued sometime in the next few days. But I can give you a sneak preview as to what we're intending. And that is that we've got 15 days in June that we are using to hear as many chambers matters as we can. That's what I've referred to as the Chambers Blitz. It's all hands on deck. Every available judge that I have is going to be used. Every available judicial resource will be used. And what the current thinking is that we will be asking lawyers who have had their matters adjourned by virtue of the court's directives, together with new matters, to submit a form which will be attached to the directive saying that I had a matter that was scheduled and I'd like that matter heard. Because there may be some matters that were scheduled and they've become redundant at this point or settled and are no longer needed to be heard. Once we get those forms back, we're going to assign times to those particular chambers applications. We have not in Saskatchewan generally adopted a view that we are assigning chambers times, but that's what we're going to attempt during these 3 weeks in June. So somebody is going to get a notice saying your chambers application is scheduled for June 12th at 10 o'clock a.m. and it's scheduled for 1/2 hour. And we're hopeful that they will be able to attend at that time by telephone, both they and the other side. And assuming they are, great. Assuming they're not, there will be a hotline that you'll be able to phone to adjust that if possible. So that's a quick answer to that. And the lawyers out there watching, we're doing the best that we can, and we should have something out in the next day or two.
Okay, thank you very much for that. Next question is with respect to case management. Has there been a push in the courts for more case management procedures during and in the wake of the pandemic? Do you think that there are resources for more case management, or that there should be? I'll put this one to Judge Bauer, please.
I've been a big proponent of case managements for a number of years. And I think that they are a very efficient way of dealing with matters. and also getting down to what are the issues that are to be essentially to be argued over. And so I've been pushing for case managements for a number of years. I think that that right now we have considerable resources for case managements because we're not running trials, and so we have judges who are available to do case managements, and we have increased our case management capability considerably during the pandemic. I think I'm hopeful that we'll do more going forward. I know that the court is pushing for them. Some council are, and some not necessarily so, but I think that we are going to, case managements are going to be on the increase throughout the provincial court in Saskatchewan.
Judge Callanuth, do you share the same sentiment with respect to case management and whether there should be more of it?
Well, certainly insofar as case management has been reducing time and in some occasions reducing time to trial, reducing time needed for trial, or in some cases narrowing the issues. All of those are issues that have continued to be used and will continue more. There'll be more pressures to efficiently use the time to deal with backlog. And so from a management point of view, and in some places from a settlement point of view, it'll continue to be a need.
Thank you. And Chief Justice Papascoul, is it the equivalent in the Court of the Queen's Bench, or are there other concerns with respect to case management?
Our court has always embraced case management, and we've had an aggressive criminal case management system in existence in this province for a number of years, and also the pretrial settlement system that we've had in Saskatchewan since the early 80s has been something that has been very successful as well. So I can assure you that we will be continuing on that. I don't think we need more because we have we've embraced it, and we've got a lot going on right now, and we hope these case managements settle a lot of cases, and of course every settled cases takes one out of the system and benefits the parties as well.
Okay. Are there any further comments with respect to case management? No. Okay. Well, that concludes our time for the webinar today. Justice Richards, Justice Papascoul, Judge Callanuth, and Judge Bauer, this has been incredibly informative. I'd like to thank each and every one of you for joining us and sharing this information. Thank you as well for all the attendees viewing. A recording of this webinar will be posted on the LexisNexis Canada website as well. With that, stay safe, everyone, and please have a great week.
Thank you.
Goodbye.
Thank you.